As I've reviewed more and more bills in the California legislature, I think that in the findings that are associated with amending ballot measures or statutory initiatives, probably need improved legislative findings. I've raised this with a number of different bills, including the Political Reform Act amendments and even some of the more recently introduced legislation concerning amendments to the CPRA, the California Privacy Rights Act. It seems that the same legislative finding and declaration is made in each and every one of the bills amending the CPRA, sort of like amending the California PRA. It's a pretty simplistic statement, and it raises, at least for me, the question whether that sort of simplistic language actually meets the requirements of any of these voter-approved initiatives, the CPRA, and other such things. It also raises concerns, again, at least with me, whether the courts will find this language sufficient to actually justify an amendment to any of these statutory initiatives. Let's look a little bit more under the California Privacy Rights Act, the CPRA. It's the California Consumer Privacy Act of 2018 that was added to the California Civil Code by Chapter 55, which was actually Assembly Bill 375. The lead author was then Assemblyman Ed Chow in 2018. The California Consumer Privacy Act was added to Division 3, Part 4, Title 1.81.5 in the California Civil Code. Now, the CCPA was amended by the CPRA, Prop 24, which was the California Privacy Rights Act of 2020. And Prop 24 expanded, certainly amended the provisions of the CCPA, and they also created, or Prop 24 that is, also created the California Privacy Protection Agency. It removed the ability of businesses to fix violations before being penalized for violations of the CCPA. It has a number of sections imposing general duties on businesses that collect personal data. It provides a number of consumer rights, deleting personal information, correcting inaccurate information, dealing with security breaches and other things. And Civil Code Section 1798.194 actually requires the privacy laws to be liberally construed to effectuate their purposes. Now, remember in Article 2, Section 10 of the California State Constitution, in Subdivision C, so that's Section 10C, it says, the legislature may amend or repeal a referendum statute. The legislature may amend or repeal an initiative statute by another statute that becomes effective only when approved by the electors, with one exception, unless the initiative statute permits amendment or repeal without the elector's approval. So this provision of the state constitution then only allows an initiative that was adopted by the state's voters to be amended by the legislature if that initiative, in its language, permits an amendment without the electorate's approval. Now, the CPRA from Prop 24 actually does allow amendment by the legislature. Section 25 is actually titled Amendment, and it provides that as long as amendments are consistent with and further the purpose and intent of this act, as set forth in Section 3 of Prop 24, then they can actually be made to this provision. And it's only a vote of a majority of the members of each house of the legislature with signature by the governor. Sometimes these limitations on the legislature being able to amend an initiative statute require a higher vote threshold, usually 2/3, sometimes even higher. So the bottom line is that the proponents of Prop 24 allow the legislature to amend the CPRA if that legislative amendment is consistent with and will further the purpose of and intent of the CPRA. So when the legislature wants to amend the CPRA, it includes a plus section, uncodified language that's at the end of the bill. And it's basically a legislative finding and declaration. So this is what we have in almost every CPRA amendment bill in the California legislature. It simply says, the legislature finds and declares that this act furthers the purposes and intent of the California Privacy Rights Act of 2020. So the question in my mind is whether this language is sufficient, or if there should be some at least generic explanation, if not specific and detailed explanation, why the legislature believes the CPRA's purpose and intent are being furthered by the proposed amendment by the legislature, and why it would be consistent with the CPRA. In other words, the legislative finding and declaration at the end of the bill should be tied back to the purposes and intent of the CPRA found in Section 3 of Prop 24. And so Section 3 has quite a bit of extensive language about its purpose and intent. In fact, it has specifically enumerated consumer rights, 8 different ones. It has responsibilities of businesses. There are 7 specific items. And then it has implementation of the law, which has 8 specific items. And so this begs the question whether these bills that propose amendments to the CPRA should include reference to any of the Section 3 findings and declarations or the purposes of the CPRA. Now, this is often the approach, although I think they need a little bit more development, but that's taken with urgency clauses and special statutes in California. If the courts examine an urgency clause or a special statute finding, at least there's a short sentence or even a short paragraph that hopefully explains why the legislature has determined a particular bill should be an urgency statute or a special statute. And I've seen this done in a few instances, like the Control, Regulate, and Tax Adult Use of Marijuana Act that was adopted by the statewide electorate. And the AUMA often has, in their findings and declarations, some specific items, 1 or 2 or 3 or even 4 I've seen in their bills, in those plus sections at the end of a bill, to justify why an amendment to the AUMA, the adult use of cannabis in this state, is in fact furthering the purposes of that initiative statute. So this brings me to the conclusion that I think just with Political Reform Act amendment bills by the legislature, and of course, California Privacy Rights Act legislation, where the legislature proposes an amendment, I think that there should be some stated rationale for these proposed amendments, so that if the legislation were ever challenged in litigation, the courts would have a clear basis for understanding why the legislature determined that that particular bill made proper amendments to the CPRA that furthered its purposes and was consistent with its intent and purposes. So really, I'm asking the legislature to consider adding some explanatory language and not just include these simple statements that the CPRA is being amended. Finally, I think to assist the courts in this state additionally is that the committee and floor analyses prepared by the Assembly and Senate consultants should also describe the stated legislative findings and declarations and the rationale behind them in their analyses. And so hopefully these 2 actions will ensure that the judicial branch of the state government will uphold any amendments to any of these initiative statutes where the legislature makes an amendment to these initiative statutes in the future.